the committee. We're continuing with our review of the initial report of Malawi. As you recall, we had the first round of questions and responses from the delegation. A few of us then asked some quick follow-up questions. I'm going to leave it to the delegation whether they want to respond to those follow-up questions now or whether they'd prefer to wait until we get another round on the second half. You want to respond now? Okay, the delegation is happy to respond now, and that's fine in terms of our procedures, absolutely. And we do seem to have the time because the delegation has been very disciplined in its responses. So I happily then give the floor to the distinguished head of delegation, Dr. Banda, to respond to our follow-up questions on issues 1 to 12, I think it was. You have the floor, ma'am.
Thank you, Chairperson and distinguished members of the committee. Yesterday, I think we left on a note where the committee posed a number of questions for our delegation, and we'll try to be as brief as possible in responding to the number of issues that were raised. The first issue that was raised related to the issue of widow cleansing. The question was whether the perpetrators of this harmful practice are brought to book and whether there are any cases before the court. Mr. Chair, your committee may wish to know that widow cleansing, though a harmful practice, was not an offense prior to 2014 in Malawi. It has been incorporated under the Gender Equality Act as a government response to this harmful practice. So on that note, it's a new act which has just been commenced. We cannot be talking about perpetrators at the moment being brought to book. We don't also have cases before the court because it's a new act, as I've indicated. But what has happened is that before the commencement of the act, there's been a lot of sensitization and civic education on the evils of this practice. And that sensitization, I think, prepared a good landing ground for the act once implemented. Among the issues, among the efforts that have taken place is that people who were professional cleansers have been sensitized and now are models. They are the ones who are in the forefront, I think, civic educating others about the evils of this, and this is a plus for the country. And also we feel that it will help the smooth and effective implementation of the act. I also want to emphasize the point that though this practice has just been criminalized in Malawi, it was not acceptable. Because I think at one point it was mentioned by one of the distinguished members of this committee that this is a practice that is acceptable in Malawi, but that statement is not correct. It has never been acceptable. It was happening underground. Once government got notice of it, government took measures to correct it by creating an offense in the Gender Equality Act. And even before the act was commenced, government conducted through the Ministry of Gender extensive civic education exercises to ensure that once the act is in place, it will be easily implemented and arrest this harmful practice. Having said that, the next question that was on the agenda, I think, was to do with victim support services and trafficking of women, whether police are equipped to investigate issues of domestic violence and what obstacles women face, and also whether we have centers and comprehensive packages to address, package of services to address the issue of trafficking of women. So I would defer that to Mr. Chizaso Nyirenda to respond to the questions that were posed in relation to those two issues. Okay.
Thank you, Chair. I'll be addressing about 4 issues. The first one is with respect to domestic violence. There were issues to do with the capacity of law enforcement agents to actually investigate domestic violence. In terms of the law enforcement agents are empowered by the Prevention of Domestic Violence Act upon a report of an incident of domestic violence to record it and to immediately commence investigations. This report may also come from the victims or even bystanders or witnesses to these incidents, and that process will actually trigger the process of investigation. So in terms of the capacity of law enforcement agents is there, and it is actually reinforced by the legislation that they can actually investigate incidents of domestic violence. I think alongside this question was the issue of what obstacles are there that stand in the way of women reporting incidents of domestic violence. As far as we know, most of the obstacles to the issue of reporting incidents of domestic violence do not just attend to women, because men also find some obstacles in terms of reporting incidents of domestic violence. So with respect to women, most of the obstacles are social in nature because of the consequences that actually arise after the reporting is done. So there will be incidents where women might be afraid of reporting cases of domestic violence because of the possible breakdown of their matrimonial union because they have reported an incident of domestic violence. The other one is more economical, where a person is actually prevented from reporting incidents of domestic violence because the person who has to be reported is actually the breadwinner. So you find that in those instances, it becomes a challenge for women to report these incidents. Although there is not proper founded research in this regard, the government agents that have been conducting training on the Prevention of Domestic Violence Act have, through those trainings, been able to actually find out from the stakeholders that these are the challenges which arise with respect to matters of reporting when it comes to domestic violence issues. With respect to men, you also find that there are also challenges. They are unable to report. Some of them, it's possibly another social reason that men feel that they cannot and they are not supposed to be victims of domestic violence, and they find it very challenging to actually rise up and go and report incidents of domestic violence. They kind of brave it and feel that they should actually not report these incidents. But it is not that these incidents don't occur, and with the sensitization of these stakeholders and the trainings which have been conducted, the stakeholders have reported that with time, there is a gradual increase in the number of cases that are reported by both men and women. But I think we are yet to compile the statistics and bring them to this committee so that we can now have a clearer picture of how far we've gone in terms of the incidents are being reported, and also compile a more comprehensive report with respect to the obstacles and their nature when it comes to reporting incidents of domestic violence. Moving on to the second issue with respect to trafficking in persons, I think there was a question as to whether there are centers in place that are actually assisting victims of trafficking in persons and what services these centers are offering. I think other than the Child Care Protection and Justice Act, which was enacted in 2010, there is no comprehensive framework within which the issue of trafficking in persons is dealt with at legislative level. So while the Child Care Protection and Justice Act does provide for child trafficking, you find that some of the structures which are going to support a more comprehensive response to issues of trafficking in persons, which will include adults, these structures are not in place. So what is happening on the ground is that the structures which have been set up and established for other purposes, like general victim sheltering, which are provided by the Ministry of Gender, these structures are the ones which are availing themselves to assist victims of trafficking. So we've got shelters which deal with the protection of women from other problems like domestic violence. Most of the most of the victim support units also have got shelters where if victims are found, then they are also sheltered in these centers. Currently, Malawi is also developing one-stop centers which are also going to provide more comprehensive services which are going to also complement on this. But it is expected that when the statute on trafficking persons is enacted, then the whole response mechanism, including infrastructure, is going to be developed to actually respond to the peculiar issues which arise with respect to trafficking. I think that said, I'll just say that all the services which you addressed in the questions, including counseling and everything else, whether there's need for any assistance, whether there's need for medical assistance, or even mental health issues, all these are going to be dealt with at these centers when the statute is actually enacted. Moving on to the issue of Thank you, Chair.
The Chairperson, the other question related to the issue of the reports of the Human Rights Commission and the Prison Inspectorate as to what happens to these reports, whether they have any impact when they're submitted to government in terms of reforms or correctional measures. The response on this one will be given by the Ombudsman, Madam Chizumira, who is also who is also a member of the Prison Inspectorate. Thank you.
Thank you, Mr. Chair, and our leader of the Malawi delegation. I have two questions that I'll respond to. The first one is, what are the mechanisms of prisoners to send complaints, and what actions are taken? The mechanisms used by prisoners to send complaints are the usual. They normally use their relatives to send complaints, either to other lawyers seeking bail and whatever they are seeking, or through the MHRC visits, or indeed through the Prison Inspectorate visits. And when those complaints are received, action is taken by the relevant institutions or bodies that I have mentioned. The second question is, what happens to reports from the Inspectorate and Malawi Human Rights Commission, and if they do reach the public domain? But before I continue with the response to this question, let me add one aspect to the mechanism of prisoners who send complaints and what action is taken. The other action that is taken is by the chairman of the inspectorate, who is a judge of the High Court of Malawi. So there are times when he is able to sit on his own motion and give out bail if it is needed. So that is one of the other actions that are taken. Coming back to the question of the reports, these reports are sent to the relevant government departments, and they are used to engage those relevant government departments. We have instances where workshops have been run based on those reports, and therefore the reports do reach the public domain. These reports are highly appreciated by the prison department itself because it informs reforms for the prisons. One of the examples is the provision of electric poles in the prisons. This was really taken kindly and appreciated by the prison department. I think with that, thank you.
Thank you, Madam Ombudsman. Moving on to the next question that was imposed. It was in relation to the death penalty. And the question was whether it has been imposed after 2007 and what we're doing about resentencing, and also the issue of reprieve period for those who have been sentenced to death, what happens. So I'll also invite Mr. Pacharo Kaira, the Chief State Advocate, to give responses to the list of questions that were posed under that heading. Thank you.
Thank you, Chair. I'll answer two questions on the death penalty as well as the pretrial custody time limits. On the death penalty, the first question was whether, since the Kamfatine decision of 2007, we have had the court imposing the death sentence. Our response to that is that of one case, Republic versus Jack Pandawe, which we can make available to the committee at a later date. In this case, the High Court imposed the death penalty. Having looked at the circumstances of the case, it was a very gruesome murder, and in the wisdom of the judge, it was thought that the suspect in that case should be sentenced to death. Secondly, on the guidelines which the courts use in deciding whether to impose a death sentence or not, presently the courts are guided by settled common law principles on sentencing, such as the aggravating circumstances of the case, maybe the victim in the case, but these are well-established common law principles. In addition to that, as we indicated yesterday, there's a special law commission which is coming up with sentencing guidelines. So once that legislation is passed, it means that the courts will be guided by those principles. But as for now, because we don't have those sentencing guidelines, the High Court uses well-established common law principles. There was also a question as to what offenses attract the death penalty. Some examples of offenses which attract the death penalty include the offense of treason, murder, as well as aggravating robbery. Those are some of the examples of those offenses. Secondly, the question of pretrial custody time limits. I think the question was what happens if a suspect is held in custody well over the prescribed time limit? Do they have any reparation or compensation? And the answer to that is that if a person is held outside the prescribed time limit, for example, the time limit says 30 days, and maybe the person is held for 60 days or 45 days, the first point to note is that that holding in custody is unlawful. As such, the person can sue for unlawful, or rather forced imprisonment. And the remedies which they can get include compensation from the court. So in essence, if a person is held outside the prescribed time limit, they can sue and be compensated for that period. Briefly, that's what we could say to those questions. Thank you.
Thank you very much. I think just to add to that, on the issue of resentencing, we had given responses previously that there's a process that is going on with the Human Rights Commission, collecting data on the people who have been sentenced, who were sentenced to death, and seeing how that list can find its way to the advisory committee on pardons. And also, just to mention the reforms that have been done to the Criminal Procedure and Evidence Code, where a person is charged, where a person is arrested and then discharged. The Penal Code has now introduced a provision where a period of 1 year elapses, then that prosecution falls away. It's automatic. It's just that I think there's need for sensitization. It's a new act, it's a new amendment, I think done in 2012. So most people are not aware of it, but it's now there on the statute book and it could be invoked anytime by a person who has been arrested and discharged. You don't have to have the offense hanging on your shoulder forever, waiting for the police to complete their investigations. Moving on to the last question that was on the list. I think the question was about the status of the ICCPR in Malawi. I think it came up again. Whether there are any other laws incorporating the provisions and how, through interpretation of the laws, the ICCPR is being domesticated in Malawi. And I think I'll ask Mr. Nyirongo to respond to that question again, and he'll combine with the other question relating to the time frames for the abortion laws. Thank you.
Thank you, Chair. With respect to the status of the ICCPR in Malawi, I think it has been stated in our report that Malawi is a dualist state, and that as a dualist state, what it means is that the international instruments that we sign do not have direct application in the country unless there's a law that is actually ratifying that agreement. And in accordance with the Constitution, we're saying that for those agreements that were in force, that were signed by Malawi or ratified by Malawi and binding on Malawi before the Constitution came into effect, those ones will continue to do so unless a subsequent law says they have no application or the agreement lapses for one reason or the other. As for those agreements which are coming in, which are being signed or ratified after the Constitution comes into force, we need an act of Parliament to ratify that instrument, and that it must state that this international instrument is going to have application in the country. So we need to have the legislature come in to give force to these instruments. So what has happened is that by way of incorporating these instruments, you'll find that some of the provisions, like in this case the ICCPR, have found their way into the Constitution and been given constitutional status in the Republic, where these provisions have now become part of the law. But as observed yesterday, you'll find that not all the provisions of the ICCPR have found themselves in the Constitution. Some of the provisions of the ICCPR have found themselves applying in Malawi through statutes. Although the statutes are lower than the Constitution, it doesn't mean that the rights that they confer are any lesser or may be enjoyed differently from those which are in the Constitution. So what we have now is that depending on the context and the subject matter which a particular piece of legislation is addressing, you will find that the provisions of the ICCPR will be considered and incorporated in that particular statute. And we have got several statutes which we can actually give as examples. With respect to the right to detention, we've got the Bail Guidelines Act, which was passed in 2000. This is, you'll find, in direct response and addressing a portion of the ICCPR itself. The Penal Code amendments adopted in 2010, which were revisions of 2000, were also addressing certain portions of the ICCPR. The Criminal Procedure and Evidence Code, the Deceased Estates Act, which deals with wills, inheritance, and succession. We also have got the Child Care Protection and Justice Act, which deals with the what we were discussing yesterday with respect to trafficking and other harmful practices against children. We've got the Gender Equality Act enacted last year. We've got the Disability Act, which we also enacted in 2012, and some of the legislation is actually in the pipeline and coming up. So what is happening is that you will not find one statute saying the ICCPR is law in Malawi, and therefore people can actually invoke it. We have actually gone to take the provisions of the ICCPR and actually expand them, because you find that the way the international instruments are actually drafted, they do not provide for instance, penalties and the context within which certain rights may be enjoyed. So what the statutes do is actually work on those provisions of the ICCPR, depending on the context and subject matter of a particular piece of legislation, expand it and make provision for all the legislative requirements. So that is what we can state with respect to the ICCPR, and that with increasing pieces of legislation that we are developing in Malawi, we will always be responding to the issues which the ICCPR addresses. So where those gaps are there, we've got institutions which develop legislation which will be responsible for actually closing in those gaps. Because at the time that we are actually developing the statutes in Malawi, we'll have to look at all the instruments that we have developed and make sure that those gaps are being closed as part of the comprehensive process of making sure that the statutes comply with the Constitution and that they are also in compliance with the general international legal framework. And that said, let me possibly respond to the final issue with respect to abortion. I think the question was that the Law Commission has got limited mandate, so what time frames are we looking at? Yes, indeed, within the context of those limitations, which are really not limitations because these are institutions which have been given different roles. You look at the program which is there to deal with the review of the laws on abortion. They have got their own time, they have got their own work plan and time limits, and it is expected that by November 2014, the Special Law Commission that is reviewing the laws on abortion will have completed its work for submission to Cabinet through the Minister of Justice so that they can consider it for possible enactment depending on the recommendations that will be made. Thank you, Chair.
Thank you, Chairperson. That marks the end of our responses to the set of questions that were given at the end of yesterday. Thank you.
Thank you very much, Dr. Banda and members of the delegation. There may be some follow-up questions to the responses to the follow-up questions. I can think of one or two myself, but for reasons of time, I would like for those to be folded into the next phase. So I'm going to invite colleagues now to pose questions in relation to issues 13 to 24. But they're also free to ask follow-up questions, final follow-up questions to issues in the first round. And then the delegation will be able to respond comprehensively. They have provided a lot of very informative information, but as is always the case, the more information one has, the more information one wants. So, the first speaker on my list for the second round, issues 13 to 24, is Mr. Bouzid. Mr. Bouzid, you have the floor.
شكرا سيد الرئيس في البداية.
Thank you, Mr. Chairman. First of all, I would like to thank the delegation for the responses that they've given us. I would like to address 3 points. First of all, 13, then 18, and 22. Issue number 13, right to a fair trial. In the response, you recognized the enormous lack of judges, and you talked about hiring new judges. The reports that we have before us are unanimous. They say that this lack of judges and judicial officers has led to a backlog of cases. And this means that people are held in preliminary detention for months and sometimes even years in pretrial detention before they're brought to court. This is a grave violation of many international legal texts. The reports also talk about a lack of lawyers. and high costs, high fees for lawyers, which also hinders the justice system. The reports we have also say that the legal aid offices that are supposed to help poor people, the many poor people in Malawi, this is an office which is underfinanced and doesn't have enough staff and not enough advisors. And this makes legal aid inefficient and essentially absent. My question is, what are the measures that you plan to take to deal with the problems I've just mentioned? Now on it's issue 17, which has to do with religious minorities. In your report, you confirmed that Malawi respects the rights of all religious communities and that there is no discrimination on the basis of religious faith. But the reports that we have before us confirm that, in general, there is no discrimination, indeed, no religious discrimination. A number of reports even say that Malawi could be used as a textbook case, which should be welcomed. But there is a unique situation, that is the situation of the Rastafari. Their followers complain of a lack of jobs for them because the government, and this is according to reports that we have, doesn't offer them jobs. So it's very difficult for them to find jobs, even in the private sector. This community in schools, the pupils are forced to cut their hair, and in some other schools don't allow them access to school at all. There is no official declaration on this subject by the government. So my question is the following. How does the government respond to these allegations, and what are the measures that are planned to restore to the Rastafarians all of their rights without any discrimination based on their faith? Now on issue 22. This is child labor and economic exploitation of children and the phenomenon of street children. The member state did not give a written response in the list of replies to the questions. There was no response to this. In the report, you talked about Article 23 of the Constitution and Article 21 and 23 of the Labor Code, which ban child labor among children under 14 years of age. But again, according to reports that we've heard, in spite of these laws, which prohibit child labor and exploitation of children, in spite of these, Malawi is one of the states where the phenomenon is most widespread. And the press talks about this a great deal, including especially on tobacco and tea farms. The reports by the National Statistics Office say that 26% of children from 5 to 14 years of age are on the labor market, and 86% of these children go to school, so they're both in school and working. The reports say that what complicates things is that the age of reaching adulthood is not uniform in the laws in Malawi. Sometimes a child is defined as someone under the age of 16. And this runs counter to the Labor Code, which defines a child as someone between 14 and 18 years of age. This creates a great deal of misunderstandings in terms of child labor. The reports also talk about underfinancing, which means that investigations and studies in this area are very difficult. How do you respond to what we've heard in these reports, and what are the measures that the government plans to take to combat the phenomenon effectively and strongly? In terms of children living in the streets, you didn't give a response, and I would like for you to explain your policies in this area and how you are working on this phenomenon. Is the phenomenon decreasing or is it increasing? Thank you, Mr. Chairman.
Shukran Saeed Bouzid. The next speaker on my list is Mr. Vatslashvili. You have the floor, sir.
Thank you very much, Mr. Chair. I want to thank the delegation for the answers provided. Let me now move to the, in the second round let me now move to the questions or issues under 14 and 18. I will start with the issue 14. It has been reported by the state party that in 2012, disability bill has been adopted into the law. Obviously, this is a positive development. Adoption of this bill underscores the commitment of the state and its willingness to ensure the rights of persons with disability. This law has a number of promising provisions, and I would very much, I would be grateful to the delegation if it could share its views to what extent the law has been effectively executed during the last 2 years. The law not only guarantees or prohibits discrimination, rather, but according to this law, government also commits to provide appropriate health care, undertakes to ensure access to the physical environment, guarantees the right to quality education, and so on. It also envisages establishment of a special fund, disability trust fund, with the purpose to support implementation of programs and services for the people with special needs. So my first question would be, my first specific question will be related to this fund. Have it already been established, and how it functions, whether it is functional already? It has also been indicated that the bill offers civil remedies to the persons with disabilities in case of violation of their rights under this law. Obviously, for any right to be truly effective, it should be a justiciable right. Could you please explore a little bit on that? What are those remedies available and offered in case of violation of the rights of persons with disabilities? Could you please also inform on what grounds individuals can appeal to the court? Is it possible to sue the government, for instance, if it fails to provide relevant service? Or I assume that persons with disabilities can also appeal to court in case of discrimination. Are there any such cases in the courts, either pending or already being solved? The law also provided the violation of requirements of this law should result in investigation, and as a result of the investigation, probably in imposing administrative penalties. For example, individuals and organizations which practice discrimination may be fined or even imprisoned, and may have their licenses revoked where it is applicable. So I have a few questions in this regard. Is there any specific body or institution that monitors implementation of this law? Is there any institution other than courts where persons with disabilities could complain in case of violation? And what are those practical circumstances in which imprisonment could be considered as an option in cases where there is a violation of the law? Let me now move to the next issue. Which is related to the freedom of expression and opinion. And let me here start also with a positive note. Back in 2011, in its concluding observations, this committee criticized provisions of the penal code that empowered the Ministry of Information to ban newspapers, and it recommended to repeal it. Many local and international human rights organizations were also very critical of this legislative provision, and it is with satisfaction I would like to note that in May of 2012, National Assembly repealed Section 46 of the Penal Code. In replies to the list of issues, the State Party also informed that in January of this year, Cabinet approved the access to information policy, and that this decision would pave a way for the enactment of the access to information law. To the best of my knowledge, this bill has not been yet tabled before the Parliament, so it will be interesting to learn what are the plans of the State Party in this regard, as it has been reported the current legislation related to the access to information falls short of the requirements of the international standards, and particularly of Article 19. It has also been reported that comparing to the period of prior to 2011, the media were more active. and freer. Broad spectrum of political opinions were available in the country's newspapers. However, there were also disturbing reports of government occasionally attempting to impose restrictions, and in a number of cases, journalists were intimidated, threatened, and even arrested. Libel remains both a criminal and civil offense in Malawi, punishable with up to 2 years imprisonment, as far as the information, as far as I know. Although there has been reported most libel cases are processed as a civil offense or even settled out of court. As I already mentioned about, there were cases when journalists were being detained, at least. In general, the state should, it was position of this committee that state should avoid penalizing the statements and comments about public figures, even if they've been published in error, but without malice. With regard to the defamation laws, it is a position of this committee that imprisonment should never be considered as an appropriate penalty for defamation. And it has been a recommendation of this committee that states could consider decriminalization of the defamation. So I would kindly invite the delegation to share its views with regard to these issues. The number of NGOs voiced concern that due to these laws, particularly the defamation-related laws, as well as actions of the government, journalists do feel intimidated, and they engaged in practice of self-censorship. I could list the cases when the individuals, journalists, were arrested in 2012, 2013, but I will not repeat those names, as the list was kindly provided by the state party itself in its replies. The list provides not only the names but also the grounds why they were arrested, and sometimes indicates what is the status quo of those cases. And I would like to ask the delegation to provide a bit more insight, or to explain the content of this list, or the chart which was provided. I think there are up to 6 individuals listed, 6 entries in this chart, more than 10 people, I believe, or around 10 people arrested during this period. In some cases, there is an indication of what is an outcome. Some cases, like with Mr. Ernesto Mahavaya, it's indicated that he was acquitted of charges, but there are some others where it's not clear what is the current status of the case. So it will be useful to learn what happened to the journalists, like that of journalist of the Galaxy Radio, who was detained because he published or broadcasted the information about the corruption within the government, and he was freed on bail after the detention. But again, to the best of my knowledge, the trial has not been conducted, and the case is pending. By the way, I should know that this particular case of Mr. Namiwa from the Galaxy Radio is not on the list which was provided by the state. It has been also reported that the controversial e-bill, so-called e-bill, was introduced in October 2012. The bill was criticized for its potential to limit internet freedom, as it would require editors of online public communication services to reveal their personal information and allow the government to appoint so-called cyber inspectors to monitor online activities. Could you please inform the committee about the plans in relation to this bill? Has the idea or the plans been abandoned, or it's still being considered? There have been also reports of arrests, although it was back in 2011, of arrests of the human rights activists and public human rights defenders. And there is information again the state party provides information about these cases. And it was quite, to be honest, it was quite disturbing to read the reasons why those human rights activists were detained. There were several of them, and the grounds for detention were because they were the state party does provide information that they were demonstrating. It was a peaceful demonstration in front of the parliament, and the demonstrators demanded the resignation of then police inspector general, and requested investigation into the alleged involvement in the killings of this individual, of the inspector general, in the killing of student activist Robert Chasova. There is no indication what happened. There is no information provided in this chart provided by the state. What is this, again, status of this case? But it was quite alarming to read that because the persons were detained just for demonstrating and demanding resignation or investigation of the murder, of the killing. So it would be interesting to learn if there been any response as a result of this detention, whether there have been investigation carried out on the if the detention was carried out lawfully and according to the law, and if there was anyone held responsible for this violation, if there was a violation, and I assume there was. There were also reports about the lack of independence of public broadcaster, and I don't want to take much of the time, but would like to invite the distinguished delegation to share its views if there is any plans to improve the independence of broadcaster, of its management and of the board of trustees, which is currently is considered not to be impartial. I mean, the broadcaster is considered not to be impartial. There are two other, I think, national broadcasters, I mean, television broadcasters, holding the license, and there also been voiced concerns about their independence and about the excessive involvement of the government and the legislator in the work of these broadcasters. So my question also would be following: whether there are, to what extent it's easy for the broadcasters or for those wishing to obtain the broadcasting license to enter the market. I know that there are many radio broadcasters in Malawi, but the number of television broadcasters, to best of my knowledge, again, is quite limited. I thank you very much in advance for the answers.
Thank you, Mr. Vatslashvili. The next speaker on my list is Ms. Majordini. You have the floor, ma'am.
Thank you, Mr. Chair. First, I'm grateful to the distinguished delegation for the responses to my follow-up questions yesterday afternoon. I have only one issue in the second round of questions, and that's issue 15. Here we ask for information on the status of the review of the 2010 amendment of the Police Act, which expanded the authorization of searches without a warrant. I do acknowledge that protection of privacy is necessarily relative, and I take note of the stringent conditions set out in Section 35(1) of the Police Act. But I'm concerned that in actual practice, there's often a thin line between what is lawful and what is arbitrary. In this regard, I have 4 quick questions for the delegation. First, is it always the case that a search carried out without a warrant is really urgent, and that the element of urgency is not interpreted loosely? Secondly, have there been any complaints in connection with Section 35(1) of the Police Act since its amendment? Thirdly, are the searches restricted to searching for necessary evidence and do not amount to harassment? And lastly, given the history of this amendment, where there were political overtones in terms of its development, are these searches without a warrant carried out in full compliance with Article 17 of our Covenant, and that the limitation to the right to privacy satisfies the test of legitimate purpose. I thank you, Mr. Chair.
Thank you, Ms. Majadina. Excuse me. The next speaker on my list is Mr. Flinterman. You have the floor, sir.
Thank you, Mr. Chairman. First of all, I would like to express my appreciation to the delegation for the very informative answers given to my questions that I raised yesterday, both in the first round and in the follow-up. I think those replies certainly help understand the intricacies of the Malawi domestic legal order, and also to understand the efforts that are made by Malawi to bring its policies, her policies and laws in line with its international obligations under the Covenant on Civil and Political Rights. I think that one of my very concrete questions has not yet been answered, and for that reason I would like to repeat it. That was the question on the conflicting information on the separation of pre-trial detainees and convicts. We have conflicting information. I would like to have clarity on that particular issue from the delegation, if possible. Today, this morning, I would like to raise questions, further questions on the issues 16, 19, and 24. Issue number 16 relates to the HIV/AIDS epidemic in Malawi, and especially the implications for the right to privacy. Let me state at the outset that I very much recognize the enormous scope of the HIV/AIDS epidemic in Malawi, and that I realize that that particular epidemic is largely due to structural factors, including the inequality, the gender inequality, the lack of resources. For that reason, I also would like to express my appreciation for the efforts undertaken by the Malawi government and for her strong commitment to provide HIV/AIDS treatment and services across the country. But in that respect, I have one specific question which relates to some of the problems that we discussed yesterday, and that is how the government intends to roll out HIV treatment and prevention services when some vulnerable populations, some vulnerable groups within the population are directly criminalized. And I'm thinking especially of men having sex with men, homosexuals. Issue number 16 addresses the status of the HIV/AIDS Prevention and Management Bill, which contains two provisions which are of concern to the committee, and that is the disclosure by health service providers and the compulsory testing that is foreseen in that particular bill. In the reply that we received from the government, it is indicated that those concerns have been addressed after consultations with all stakeholders, but no further information. And I'm asking the delegation, the head of delegation, what exactly the outcome is of those consultations. Does it mean that the provisions, those two provisions, the disclosure by health service providers and the provision on compulsory testing, that's Article 10, I believe, of the bill, have been withdrawn, and that now very soon that particular bill will be sent to Parliament and to be enacted as a law of the Republic of Malawi? Or is it still pending? What exactly is the status? Could you clarify the situation in somewhat more detail? That is my question about issue number 16. And then I move to the issue number 19, which relates to that fundamental freedom of assembly and association. The question is about the Commission of Inquiry, which was set up to investigate the handling of demonstrations on the 20th of July 2011. And I was very happy, Mr. Chairman, that the head of delegation in her very interesting presentation yesterday afternoon referred to that committee, that Commission of Inquiry, and informed us that that commission has finished its work and has come up with a wide range of recommendations. I'm citing the that of delegation's presentation. She further indicated that those recommendations have been useful to the extent that since 2011 we have had demonstrations organized by civil society coalitions which have passed on peacefully. But yet there is a problem, because although the Committee of Inquiry has finished its work, so far no prosecutions have been brought against those responsible for the killings, and no compensation has been paid so far. And for that reason, I would like to have, if possible, somewhat more precise information on the status of the outcome of the Commission of Inquiry. And I also would like to appreciate it if we could have some more detailed information on the lessons that are learned from the report of the Committee of Inquiry. What recommendations have been especially useful to the government in assisting the government respecting the freedom of peaceful assembly? And in that respect, I would like to ask a question about paragraph 72 of the report, in which it is said, and I quote, that the challenges faced in the enjoyment of these freedoms, and that is the freedom of assembly and demonstration, are enormous. End of quotation. And I was intrigued by that particular sentence. What are the enormous challenges of the freedom of assembly and peaceful assembly and demonstration? Could the head of delegation give us some more information on the challenges that the government sees in respecting this particular freedom? And would it be better in place to underline the potentials of the freedom of peaceful demonstrations and assembly, because that particular freedom of assembly and association, like the freedom of opinion and expression, are, I think, to be considered as the cornerstone of any democratic society. And the role of the government is first and foremost to respect those rights, and only in very limited circumstances to restrict those rights on the basis of the criteria provided for in Article 19, 21 and 22. And that brings me to the final question, final issue, Mr. Chairman, that I would like to raise this morning, and that is the issue of dissemination of information relating to the covenant. Issue number 24. In the replies to that, the list of issues, there is no further information on this paragraph, and maybe that's because in other parts of the responses to the list of issues, some information is given on the efforts of the government of Malawi on the dissemination of information. To give you an example, I was very pleased to read and to be informed also yesterday afternoon by the head of delegation about the establishment of a task force in which also some civil society organizations took part in the preparation of the report under the covenant. My question would be whether the delegation could inform the committee what plans the government of Malawi has after the examination of its initial report here in Geneva. How will the concluding observations be disseminated? What role does the government foresee for example, the Malawi National Human Rights Commission. How will the judiciary be informed about the conclusions of the Human Rights Committee here in Geneva? How will the general public be informed about the outcomes of our discussions here in Geneva? And I very much would appreciate if the delegation could give us some ideas about how she will tackle these particular issues after its return to Malawi. Thank you very much, Mr. Chairman.
Thank you, Mr. Flinterman. The next speaker on my list is Ms. Waterval. Ms. Waterval, you have the floor.
Thank you, Mr. Chair. I thank the distinguished delegation for their replies on my issue yesterday. We have taken note of your reply on issue number 20. I'm going to tackle issue number 20, 21, and 23. We have some partial answers to these issues, and of some of those issues there is no reply. With regard to the sexual abuse of children, we know that this is partially taken care of under the penal code. Children comprise boys and girls, and the offense regards sex with a girl under 13 years of age. Does this law also offer protection for the boys? And if not, what measure are you going to take to criminalize sex abuse of children regardless the sex of the child? And what steps are the state going to take to prevent sex abuse of children? We have information that recently a man has sexually abused a child, and he has been set free after the family received the sum of about $17 American US dollars. And the family, withdrew the case against him. He has also infected the girl with HIV virus. This example illustrates that the offender could have only been set free with the involvement or with the consent of the judiciary. Can you comment on that? And we also like you to comment on the corroboration rule, which has been applied in court, especially regarding witness in these kinds of cases. With regard to issue number 21, and that's on the early marriages. The Child Care Protection and Justice Act prohibits forced marriages against children, but it is silent on early marriages. Malawi is one of the highest rates of child marriages in the world. Some are as young as 9 or 10 years when they are married. This is one of the urgent reasons for the state party to the enactment of the Marriage, Divorce, and Family Relation Bill, which proposes the minimum age of marriage be raised to 18 and has stronger protection of children against forced marriages. We have heard the reasons for the delay, but this bill is of 2006. So maybe you can put some more pressure on government to enact this bill. With regard to issue number 23, I will associate myself with Mr. Boussit in his questions to issue number 17. And I have just one question on this issue, and that is that we have information that there is some tension between Christians and Muslims in the Mangochi, I don't know if it's city. So we ask and urge the state party to have a look at this region and try to sensitize people that everyone has the right to freedom of religion, also in Mangochi. And with that, Mr. Chair, I thank you.
And I thank you, Ms. Vatafal. The next speaker on my list is Mr. Zlatescu. You have the floor, sir.
Your microphone, please, Mr. Slestescu.
Thank you very much. Yes, I am taking my share here in welcoming the Malawi delegation and thanking them for their in-depth explanations and for their detailed and professional manner of explanations. And then I would like to comment on issues number 21 and 23, now aligning with my colleague and country rapporteur, Mrs. Waterval. So, in April 2014, Human Rights Watch urged Malawi's first woman president, Joyce Banda, to publicly support prompt enactment of the Marriage, Divorce and Family Relations Bill, which includes strong protections against child marriage. Accordingly, the government of Malawi should increase efforts to end widespread child and forced marriage, or else risk deteriorating poverty, illiteracy, and preventable maternal deaths in the country. As usual, my questions will touch on sociological aspects of Malawi's development policies. According to Malawi government data, 50% of the girls in this country will be wedded by their 18th birthday, with some as young as age 9 or 10 being required to marry by their families, most often in repayment of debts between neighbors. UN statistics shows that only 7 other countries, Niger, Chad, Bangladesh, Guinea, Central African Republic, Mali and Mozambique, have higher rates of child marriage. Child marriage thwarts girls and women from participating in all spheres of life. The practice encroaches upon the rights to education, health, work, freedom from physical, mental and sexual violence, and ignores completely the principle of free and fully consented marriage. So I think it's a good thing that we don't see in Malawi any cases of genital mutilation, but that stands for another unacceptable practice. Malawi should, of course, increase efforts to avoid facts such as the custom, yes, of trapping Malawian girls, as we learn from other human rights reports, into early pregnancies and marriages after being forced into a rite of passage called initiation. I don't know how widespread this rite may be. You could comment on that. The traditional custom is intended to train girls to become women. We learn from human rights reports, yet in some cases, in some communities, girls are persuaded to engage in premarital sex to cleanse, yes, and get ready for their husbands. In some cases, parents have been reported as calling upon and paying adult men to sexually initiate their daughters, who are forbidden from using condoms because of cultural beliefs. Is this true or not? Such practices help explain why girls are more prone to HIV in Malawi, where 10.6% of the population is already infected. More women than men are HIV positive, nearly 13% versus 8.1%. In the 15 to 24 age group, HIV prevalence is nearly 3 times higher for girls than boys. An important Malawi human rights activist declared recently that adolescent pregnancy is a key driver of child marriage in Malawi. Girls lack the power to negotiate safer sex with men, do not know about contraception, and are forced by their parents to have sex for money or food. Many end up becoming pregnant and being forced into marriage by their families. The phenomenon is rampant in poor neighborhoods. Official Malawi government infos have acknowledged that between 2010 and 2013, more than 27,000 girls in primary and more than 4,000 girls in secondary schools dropped out due to marriage. During the same period, another 14,000 primary school girls and more than 5,000 girls secondary school girls dropped out because they were already pregnant. In Malawi, the literacy rate for men is 74%, for women it is only 57%. Many Malawi teenagers have reported that early marriages as bringing to a quick and undesired end of their education prospects, their aspiration to learn a profession such as doctor, teacher, or lawyer. Many declared that they could not return to study after marriage because of lack of resources or of adequate schooling programs for female adults in their situation. Others reported that their husbands or in-laws would not permit them to return to school once married. Some related the interdiction to study with mere verbal and physical assaults by their husbands and in-laws. Health workers in Malawi have warned against the risk of childhood pregnancy when girls marry young, including death, obstetric fistula, premature delivery, and undernourishment. Malawi's maternal mortality rates at an alarming 675 deaths per 100,000 births. Take the necessary legislative steps for the enactment of the Marriage, Divorce and Family Relations Bills and try to coach us or to explain us more, if you could, yes, what is going Malawi to do in this situation. When or whether is Malawi going to pass into law the education bill, which would allow a plan to implement the provision on compulsory education as well. Does Malawi, on the other hand, have the intention to denounce and criminalize the so-called initiation rites performed on children, which is, according to Western standard, a typical case of infant abuse, yes? Advance the national action plan to stop and warn against the harms of child marriage. Advance a national policy on teenage reproductive health, maybe. Introduce law enforcement and prosecute violence against women, specifically adding here child marriage under the pertinent law. Back non-governmental organizations in their efforts to screen and assess programs on women-related violence, infant betrothal, and child matrimony. Promote and upkeep shelters for survivors of gender-based violence, including abused children. So these would be my questions, and thank you very much for letting me speak.
Thank you, Mr. Zlatescu. The next speaker on my list is Mr. Shani. You have the floor, sir.
Thank you, Mr. Chair, and I want to thank the delegation for the response I received to my question yesterday. I have one very short question, and it goes to the age. It follows in the same track that Mr. Bouzid and Madam Waterfall have trodden with respect to the definition of childhood. And the question goes to the issue of criminal responsibility. And whether there has been progress in implementing the recommendation of the Committee on the Rights of the Child from 2009 to raise the age of criminal responsibility from 7. I would appreciate, I understand there was a bill at the time which considered raising the age, I think, to 10. And the committee has expressed its concern even about 10 as an age which may be too early for criminal responsibility. But according to information we have from 2013, the age has not been raised. So I was wondering whether you can, maybe the information we have is incorrect, and maybe there is something which is in progress and you can update us on. Thank you very much.
Thank you, Mr. Shani. Mr. Sital Singh, you have the floor, sir.
Thank you, Chairman. I'll be just addressing one question on issue number 18, and forgive me for referring to one specific case in the list of persons given under 18. I'm referring to case number 6 of Mr. Capito, and because that case did receive some international attention, especially in Geneva here, and that gentleman used to be the former chairperson of the Malawi Human Rights Commission. And we see here that he was arrested without a warrant of arrest. He was detained just for 1 day. But then we see that he was accused of possessing guns and seditious materials, but no weapons or materials were found at his place. Nonetheless, he was charged with possessing materials with seditious words. So I would be grateful if I could be enlightened about the distinction between seditious materials and possessing materials with seditious words. And he was also apparently charged with having undocumented foreign exchange, but we do know that that gentleman used to travel a lot and would have foreign exchange in his possession because he would be attending conferences and workshops. I don't think this case had any bearing on this exercise of reaccreditation of the Human Rights Commission with the ICC. And as the distinguished head of delegation mentioned, the reaccreditation is affected by the issue of appointment of commissioners. But as I said, this case did draw some international attention, and I would be, as I said, most grateful to be enlightened about the outcome of this case. Thank you.
Thank you, Mr. Sital Singh. I see no one else seeking the floor. I'll allow myself a couple of quick follow-up questions to the earlier follow-up questions. First of all, if I understood correctly, the way in which, according to the Ombudsman's reports and the Inspectorate's reports reach the public domain is via education. Does that mean that there are no reports published either in hard copy or in electronic form that are available to the public at large? And if not, why not? The distinguished delegate gave us some examples of capital crimes in Malawi. I think we need more than some examples. We need all examples of capital crimes in Malawi. And in particular, of course, we're going to be interested in those like aggravated robbery that don't even necessarily have lethal consequences. The question of detention beyond time limits, I was glad to hear that it's possible, as is appropriate, for a person then to sue and gain reparation. Are there any examples of such suits actually having taken place and having prospered, and what kinds of reparation were received? And finally, this is follow-up to a point I think raised by Ms. Majordina. Is it true that there's no such thing as spousal rape in Malawi? It's an issue that I'm particularly concerned about. It took my own country a shamefully long time to recognize the issue, and I'd be glad to know if the issue has been addressed in Malawi. According to NGO information, it hasn't, and if not, what plans there are. So with that, that's your next menu for you to concert about, to discuss how you're going to, how the delegation is going to respond. Again, a 15-minute break, and we meet again at 25 to 12. Thank you very much. The meeting is suspended.